Good morning, everyone. Today is Thursday, April 9th, 2020. It's approximately 10 a.m. Pacific Standard Time. Thank you again for joining us on our daily podcast. Today, we're going to be talking about the topic of paternity. I'm once again joined by the Family Law Legal panel. I will give them an opportunity to introduce themselves. But I do want to remind the participants and the viewers as you come into the room, please make sure that you're muted. And if you have any questions, please make sure that you send them to us. With that said, Gina, tell us a little bit about yourself.
Sure. My name is Gina Familaro. I am a partner at Family Law Matters. I've been an attorney for 22 years. I have a wonderful husband of 28 years and 2 children. I've been practicing in Orange County for 9 years and Riverside for the balance. I've always done family law.
Thank you, Gina. Colleen.
Good morning, everyone. My name is Colleen Robinson. I'm a family law attorney here at Family Law Matters. I have been practicing family law now for a decade, which is hard to believe as an attorney, though I've been in the family law field for, I think, 13 years, even while I was in law school. I practice here in Riverside County and also in San Diego County, though I've appeared all over Southern California.
Thank you, Colleen. Christy.
Good morning, everyone. My name is Christy Bergamo. I am a senior attorney here at Family Law Matters. I have been practicing 17 years. I've been certified to be minors counsel in the courts in Southern California. I am currently an instructor at the University of California, Riverside in the paralegal program. And just welcome, everybody.
Thank you, Christy. And I am Kishore Shahada. I'm the managing partner here at Family Law Matters. I've been an attorney for a little over 2.5 years, and family law is all I know. So let's get to it. Gina, what is a paternity action and who needs it?
Sure. Paternity action is a lawsuit filed with the courts, and it's to determine who the father and mother of a child is, what custody and visitation rights should be established, meaning where the child should live and when they should see the other parent, and whether or not support should be paid and how much. Who needs it? I would suggest anybody needs a paternity action who has a child out of wedlock. And the reason for that, Bishoy, is that when you have a child and you're not married, it becomes kind of a free-for-all. It makes it easier for one side to deprive the other of visits. It makes it so much easier to not get the support that the child is entitled to. A paternity action just establishes the rules of the road. It would be like driving a car with all the traffic lights out, and people don't know when to stop or when to go. It's kind of the same thing without a paternity judgment. It allows everybody to know what their rights and what their responsibilities are.
So what are the issues that are addressed in the paternity action?
Sure, there's 3 things that are established in a paternity action. Like I indicated, the first thing is who's the father and who's the mother. The courts will declare paternity. They'll make a finding of who the parents are. The second thing they'll do is they will establish where the primary home of the child is, whether or not it's 50-50, where the child will go to school, and when the parent will pick up the child, when the non-custodial parent will pick up the child, things like where will the visitation exchange occur, who can pick up the child, those types of things. And then the final one would be to establish statutory child support. Child care is included in that. Health insurance is included in that. And when I say that it establishes the father and the mother, Bishoy, it can be a father, mother as well. It's who the parents of the child are, who has rights to raise this child. That's the point of a paternity action.
Thank you, Gina. So if I understand you correctly, if the parties have lived together for a long period of time, but are not married, will the paternity action address that issue or will it not?
It will address the issue if the parties have children. So if two people have lived together for a long period of time but have no children, a paternity action won't help them. A paternity action specifically is for parentage, hence the name paternity action. It's derived from that term. So it establishes the rights of parents and things surrounding the raising of the child.
And if the parties purchase the home together, is that the issue of the home where both parties are entitled but are not married? Is that issue addressed in the paternity?
So a paternity action only establishes, again, rights to raise the child, what the rules of the road are in raising the child. Things like property that's accumulated. Let's say that these people are living together for a long period of time. Sometimes we get cases, as you know, Bishoy, where the parties have lived together for 20 years and never got married. And they call us and say something along the lines of, I live with this person most of my life. I've given up everything. I want him or her to support me. Is that something that can be addressed in a paternity action? No. Buying property together cannot be addressed in a paternity action. Dividing cars, dividing personal property, dividing debts. Sometimes one person will allow another person to be on their credit card. It doesn't address those issues. It doesn't address support other than child support. It addresses nothing, Bishoy, but the raising of the party's child.
Thank you, Gina. Now tell me, how does a paternity action protect my rights as a father?
Sure.
Or as a parent. I apologize.
Sure. Well, hopefully you'd be a father, right? But how would it protect your rights? It would protect them because, again, it would give you the rules of the road. There's multiple scenarios. So, for instance, some people, they're not on the birth certificate. Some people don't have any rights because they've not even established that they are the father. Even if you are on the birth certificate, though, in order to get court-ordered rights, you have to file an action. So for instance, let's say that you have a ex-girlfriend or even a current girlfriend and you're raising a child together successfully. Without filing a paternity action, either one of you could pick up and take the child and move away, and then now you're scrambling to try to get back what you had, which is maybe substantial visitation. Perhaps you're receiving child support, voluntary, and the other side stops paying. There's no way to enforce that. Let's say that you're getting $200 a month in support and you are really entitled to $400. The only way to enforce that or to create those rules is by filing the paternity action.
And Gina, so if I understand you correctly, if I am on the birth certificate, but things are not working out between myself and the other party, do I need to file?
I would suggest that if you're on the birth certificate and things are working out between you and the other party, that is the time to file. Because when things are working out, that's when you're going to get the best result. That's when you're going to get the most favorable outcome with regard to visitation. That's when it's going to be the least stressful and the least difficult to get the orders that you're looking for. Once you're having conflict, absolutely you should file. But then now you're trying to fight for visitation, perhaps, if you're not getting along.
Thank you, Gina. Colleen, I want to move on to you with the process of the paternity action. What is the process?
Well, you've got to start with a petition. So either parent can file a petition for paternity. So you got to file that and with the court, and then you got to serve the other parent. So that starts the paternity action. From there, if you're looking for, as Gina was talking about, a parenting plan, child support, the birth costs, if that's an issue, we can deal with the name change of a child. You've got to ask the court from there on to do something. So that's filing a motion. So then you would file a motion asking the court to make specific orders regarding your child. So I want to be able to see my child, for example. I want a parenting plan. That needs to be included on your request for orders. I want child support. I need child support. That needs to be included as well. So then you file a subsequent document with the court asking for a court date for the court to make that determination. So if you're asking for a parenting plan, which you should, as Gina said, for the variety of reasons that she provided, then the court's going to give you what's called a CCRC date, which is child custody recommending counseling, where the parents would both go to the courthouse and meet with a child custody evaluator to try to come up with an agreement as to a parenting plan. And if there is no agreement, then that child custody evaluator is going to make recommendations to the court and provide those recommendations for the time of the hearing that the judge is going to consider. So then when you get to your hearing date, the court's going to make the orders on the things that you requested the court to make those orders on. So, and then after that, we still need to get a final judgment to conclude the paternity matter. So that's kind of, in a nutshell, the process of a paternity case.
So if I understand you correctly, if the parties right now are working together, the same question that I presented Gina, if the parties are working together, do they still need to file the motion for the request for order, or can they just initiate the paternity action and then file an agreement?
Well, that depends. I think there could be some strategy in still filing for a request for order, a motion, because if your agreement falls through, then you still have a hearing date to get the orders that you need. So as Gina was saying, to disseminate your chaos and that you have a concrete plan of where is the child going to be and with whom, and support and things along those lines. So I always think it's a good practice to still file your motion, get an agreement. If you get an agreement, great. It's so easy to take your court case off calendar. But if your agreement falls through, then you don't have to put your paperwork back in line or in line and have to wait another couple months to get into court.
Thank you, Colleen. So how is visitation then decided? How is it, let me rephrase, how is visitation decided?
Okay. So as I was saying before, when you file your motion, so again, you have to ask the court to do something for you, and the petition by itself isn't going to get you there. You've got to file a motion for it. So when you file a motion asking for visitation, the court, as I was saying before, gives you a date, an appointment to meet with a child custody recommending counselor. In Riverside County, San Diego County, it's called Family Court Services. I know every county kind of does it differently. This is if it's a recommending county, and that's something altogether different, but a different topic. But in Riverside County, you're going to go see a child custody evaluator prior to your hearing date at whatever time that they give you. That child custody evaluator, they have a background in usually social work, or sometimes I've seen them a family marriage therapist or something along those lines, but they've been given the training and the credentials necessary to make recommendations as to what is an appropriate parenting plan for your child, and they use a wide variety of factors, but something that's geared toward the age of your children, and then based upon the parties' information that's provided. So you would go to the courthouse and you meet with this child custody evaluator for probably, it's about 2 hours or longer. And the goal is to try to get the parents to come to an agreement, because that's always in the best interest of the parties, or I'm sorry, it's in the best interest of the children if parents aren't fighting and they can come to an agreement. But if an agreement isn't reached, that child custody evaluator is going to generate a report that is pretty detailed. It's over 5-10 pages long, and that's provided to the parties if they have an attorney, to the attorneys, and then to the judge. And then at that point, you'll be going to your hearing. The judge has already reviewed, or should have already reviewed, the recommendations by the child custody evaluator, and then the judge will hear from the parties as to whether or not you want to adopt the recommendations, and if you have any changes and why. And then the judge is going to make orders establishing a parenting plan going forward.
Thank you, Colleen. And how long does this process normally take then?
So from the time that you file your petition, and then your decision from there after you file, am I also filing an RFO for custody visitation support and whatever other issues that you may have. So from the time you file that request for orders And then your hearing date, it's anywhere between, I would say, 6, 8, 9 weeks from when you file your RFO. It just depends upon the court calendar. And then from there, you need to draft your final judgment. After you get those initial orders, you need to draft the judgment to conclude your case. So it could take, a paternity action could take anywhere for 3, 4, 6 months or so, or it just depends upon the parties as well. But your first court date, that's going to be a couple weeks after you file your RFO. That's gonna, for the most part with paternity cases, that's where the majority of the orders are going to come from, is that one hearing with custody, visitation, and support.
Okay, so let's get into a little bit more detail. So how do I know as a parent if I am on the birth certificate?
So first I would ask, do you recall signing anything at the hospital when your child was born? Were you present when the child was born? Because the hospital will have you sign something, and if you recall signing it, from there you could either go down to the public records and see if you can get a copy of the birth certificate. You can also contact Human Health Services to get a copy of what you signed at the hospital as well. So there's a process involved with that. So that would be where I would start if I was talking to someone wanting to know if they were on the birth certificate.
And if I am not on the birth certificate and I want to get on the birth certificate, how do I go about doing that?
Okay, so to get on the birth certificate, if you're not on the birth certificate, that would require filing your paternity action, that you're establishing paternity, or you're establishing parentage, I should say. So you want to file your petition, and then you'll want to also file an RFO asking to be added on to the birth certificate. So then what happens is when the judge makes that determination that you are the parent, then you'll get a certified copy of that order, and then you can go and amend the birth certificate, add yourself onto the birth certificate.
And then is that the same thing as getting or giving the child my last name if I want the child to have my last name?
Yes, that would require the same process, and asking that your child be added on, or that your child has your last name. You make that request to the court, and the court will make, at the time of the hearing, will make that determination in regards to the child's last name.
And does it matter if mother does not agree?
Well, it's up to, regarding the last name of the child, the court does have discretion in regards to what the last name should be. What we've seen trending is that what the court does is will try to, in some fashion, get both names on the birth certificate of both mother and father. I know that from talking to both Gina and Christy, that it's been a triable issue. It is. So if there isn't an agreement between the parties, you're leaving that up to the judge to decide.
Thank you, Colleen. And now, what happens if I can't? So I want to file a paternity action, but I can't find the other side.
This actually happens more often than people probably think. And in the Code of Civil Procedure in California, that's how we operate as attorneys, as anybody involved in the legal system, is how the process involved in doing a lawsuit or involved in legal proceedings, that if you don't know, you still have to make reasonable efforts to find the other party. So the court's going to require you to, you could do like what's called a skip trace. You can hire somebody to do a skip trace, to do a name search. If you had an address at one point, and they're going to, the individuals that do that are very skilled in what they do. They can see if they can track this person down to another address. They can run, I think they can do DMV records. I mean, like, it also involves like utilities and all kinds of things. So when you do a skip trace, you can get a lot of information. So you still have to go through your due diligence of trying to find that person. Do you know any of their family members? Have you reached out to them? What efforts have you made to try to locate them? Because what the court will do is that if you make all these reasonable efforts to try to locate them, there's alternative ways to serve somebody. So one is by substituted service, where if you have an address, someone over the age of 18 answers the door, the court could deem that as effective service. Another way is what's called service by publication. So you have to ask the court and give all the facts, saying, this is everything I've done. I have no idea where they are. I can't find an exact address. This is where I believe they are. the court will allow you to put in a legal notice in a newspaper publication. And after it's run for 3 weeks, then you provide a copy of, there's things that you got to do. You got to provide a copy of that ad and a declaration from the newspaper or circulation or publication to the court. The court will then determine that to be effective service, and you can move forward with your case.
And Colleen, so if a party is pregnant but hasn't given birth to the child yet, should they file for a paternity action?
That's a good question. And the answer is I would say yes, because especially if you're a pregnant mother and you are going to need this support, you should not wait to do that, because there is a lag once you file and then when you get to court and get those orders. So I know in our previous podcasts, we've talked about preserving and protecting your rights and retroactivity. The sooner you file, when the court does hear your case, the court can go back to that date that you filed for that request. So now you're going to be covered for the time that you filed the request and going forward. And the longer you wait, it's the longer that you may not be receiving the relief that you're requesting. So in my mind, if you're in need of support, you need to do that right away. And California has determined that you don't have to wait for your child to be born in order for you to petition for that relief.
Thank you, Colleen. Christy, I want to bring you in on the rights. So what if I don't believe that I am the father? What are my rights?
Well, obviously, if you're served a paternity action where the other side is listing you as the father and you don't believe so, you need to answer that petition, okay? So it's very imperative that you don't just, oh, I'm not the father, let me throw this in the trash because it doesn't apply to me. You need to answer the petition, and you indicate that you don't believe you're the father. And then what will happen is a few things. One, obviously you can take a paternity test, and you can request that in your answer that you take a paternity test.
Okay, so talking about the birth certificate and being on the birth certificate, then what does it really mean that I'm on the birth certificate?
Well, it means you're on the birth certificate. It means that you acknowledge that you are the parent of this child. But I think what both Gina and Colleen have pointed out, that that's not the end of the story, not at all. I have a lot of people come in and see me and say, well, you know, I don't need to do anything because I'm on the birth certificate. That's not correct. The birth certificate does not give you legal rights. You have to establish those through a paternity action. So that's just simply not enough. And if, you know, the sooner you establish those rights, the better, because of all the reasons that Gina states, that it gives you a roadmap and it shows you what you know, your rights look like.
So if I am not the father, but I've raised the child since birth?
That's a very complex issue, and I don't advise any person to tread those waters alone. You definitely need an attorney involved in those issues, because we have in California what is called a presumptive parent. So if you've held the child out to be your own for a certain statutory period of time, you can actually establish paternity even though you aren't the biological father. So that is a good question for an attorney to sit with you and guide you through it. But absolutely, paternity in California is not confined to biology. There can be 2 parents, there can be 3 fathers. I mean, that's what I'm saying. They've expanded the notion of what is a parent in the state of California. So you can actually be deemed a father without having been biologically related to the child.
So then what does it mean to have legal rights?
Well, what it means is that once the court deems you to be the parent, then you have rights to visitation, you have rights to support, you have a duty to support, you have the ability to ask for the child's name to be changed, to be placed on the birth certificate, but none of that takes place until you initiate the proceeding of paternity.
Christy, if I'm concerned that the other side, I'm sorry, I'm hearing an echo in the background. Is anyone else hearing it?
Yes.
Little bit, yeah.
So let me try this again. If I am concerned that the other side is not taking care of the child, whether they're living with someone who's got a criminal record, or I fear that they're neglecting the child or children and not taking care of them, or they're simply just putting him in danger, what can I do?
Well, you file your paternity action. You establish your rights to be able to protect that child from those various scenarios. And you can't really do that until you file the paperwork. And that could be the mother concerned about those issues. So you establish this person as father to exclude them from being involved with the child based on the reasons that you're concerned. If you're the father and you're concerned about the mother in that regard, again, you have to establish that action. And Colleen did a very nice job talking about how you file your initial request for order, or motion as we call it. And you establish what your concerns are, and you ask the court to make orders accordingly to protect the child.
So let's say that now orders are made, but I don't agree with them. What can I do at that point?
That comes up quite often, B. You know, we tried, it's not a one size fits all. It's not what I always tell my clients, you know, what works when the child is 2 or 3 may not work when the child is 5, 6, 10, 12. You know, the support may change in that regard as well in terms of the financial circumstance. So you always have a right to go in and request a modification of those orders. So when we were just talking about, you know, neglect or abuse or drug concerns, those might not be present at the time paternity is established and that judgment is filed. So if those come up later, you absolutely have a right to go into the court, file another request for order, and it would be a modification to change the initial orders and on the reasons you state. So for instance, drug, neglect, anything like that. And it involves support as well. If say for instance, you were earning X amount when the order was made, and you know, you're earning less than you were after that, then certainly you have a right to go in and ask the court to review those orders. But it has to be a change in circumstance, because the standard by which the court will look at these circumstances is a change. It's not, gee, I don't think I like this anymore, or gee, I don't think I want to pay support anymore. That's not going to get it done. It's got to be a change in what's going on. And certainly the consideration in terms of visitation and custody is always what is in the best interest of the child.
So is it fair to say that, sorry, that echo comes and goes. So is it fair to say that one must be careful about requesting a modification without speaking to an attorney first, considering the fact that what I might, as a layperson, think qualifies for a modification may not be up to par with the court standards?
Absolutely. And I've been in court more than once where I've had to defend my client about a frivolous lawsuit that's been filed on the other side. And I not only am successful in defending that there's been no change in circumstance, but I also ask for the attorney fees. And that is a part of the puzzle that people don't seem to realize. If you file frivolous lawsuits and you don't know what you're doing, the sanction could be more than just the court denying your motion. And so you have to be very careful. And it is just a matter of going over the facts. What are your concerns? What are your questions? You know, does this rise to the level? And obviously we're in a position because, you know, at least me, I'm there every day. You know, I know exactly what's going on. I mean, obviously you can never anticipate a result, But again, there is a standard, a legal standard by which people have to satisfy in order to change their orders. So it is imperative that you talk to somebody in those situations, for sure.
And Christy, I got another question that I received. What happens if after the orders are made, one party moves away?
Well, first of all, usually in your paternity judgment, which are your final exit orders in a paternity action, it indicates, and again, you have to read through your judgment carefully, it indicates what needs to happen if that occurs. So usually in a paternity judgment, there's notice. The other side has to give you notice of a move. And when that happens, your judgment dictates, and they're all different, your judgment dictates who needs to file the motion if they object. So if you agree to the move, then clearly you want to come in to draft an amendment to your judgment or a stipulation in order to amend your judgment to lay out not only where the child's moving to, what the visitation's going to look like, and so forth. So if you agree to the move, then it's a stipulation. If you don't agree to the move, which is usually the case, because no parent wants their child to move away from them. So usually it's the case that you object. And if you object to the move, then you have to file an objection, which is a request for order. And again, this is very specific to what your judge or what your judgment says in terms of who has to file what in terms of an objection. So say you're the party that wants to move, okay? So I always think it's a good rule of thumb that obviously you don't pick up in the middle of the night and take your child to another jurisdiction. That is going to get you in a lot of trouble with the court, okay? So don't ever act unilaterally. You have to notify the other side and plan ahead. That is the big key here, because if you know, again, which is normally the case, the other side is going to object. This is not a simple procedure. We don't get to go, so if the other party objects, we file our request to move with the court, okay? So the judge usually on the first hearing usually doesn't make that decision. The judge is usually going to want some additional information, whether that be a custody evaluation, a trial. There's a number of different avenues. So I would anticipate if you want to move, then you need to give yourself, in my opinion, a year before, at least 6 months, at least. But I would say, just to be cautious, a year to plan ahead, to file your motion, your request to move, and to go through all the necessary proceedings that are going to entail for you to move, because it's a big deal. Like I said, I mean, you know, no parent wants their child away from them. So it's usually a battle. And again, you have to be prepared financially, emotionally, and otherwise.
So let me ask you this. In considering all of these different permutations and all of these facts that we need to consider, why should someone hire an attorney then?
Well, I think this entire podcast has shown why you need to talk to a lawyer. This is not an easy subject. I think, again, the misbelief of most people, and it's understandable, is that if they're on the birth certificate or if they sign something at the hospital, then that's the end of the story. It establishes their rights, and it doesn't. And I think what's clear from this podcast is that it doesn't. So how do you navigate that? And I think, again, from this podcast, we've heard all these various permutations of what needs to be pled, what needs to be considered with the court, and so forth. So obviously you need an attorney, I believe, to navigate you through this. I can't tell you how many times I've been in court when I see someone who's representing their self, and say, for instance, the other side has an attorney. And I think in one of our podcasts, we were joking that, you know, attorneys speak the language. We speak the court language. And to see this person struggling because they don't understand the process, they didn't plead it right, and they walk out with a really bad custody order. And it's devastating and it's difficult to change. And my feeling is these are your children. These are our children. These are the most precious things in our life. And if you can't pony up the money to protect the most precious thing in your life, I feel bad for you, because again, this is not easy. The paperwork itself, I implore any of our listeners to go on the California court's website and look at the documents that you need to file. And again, this is not an easy issue, and it is establishing your rights as a parent. What could be more important? And I think you do need an attorney in this particular case. And we didn't even go into, I think, that significantly, that there's a there could potentially be a Department of Child Support Services component to this, which again, I caution anybody to navigate those waters themselves.
Thank you, Christy. Colleen, anything to add on that note?
No, I just, not really. No, and I keep talking. But I just think that you need to start with an attorney, give us a call, let us help you navigate these waters. And also, oftentimes what I hear from clients is that they try to do this themselves. They think that the courthouse is going to help them, that the clerks are going to help them, and they can't. And even the self-help center is limited to what they can do. They can't tell you what to file or how to ask for things. They can't really give you legal advice. They're there to give you a set of paperwork and documents, but they're complicated. So let us help you navigate these difficult and complicated waters, and that's what we're here to do.
Thank you, Colleen. Gina, anything to add?
Well, I just want to say that there are steps throughout the entire process that we can help you with. For instance, there's going to be a point where you're going to have to meet with a counselor. CCRC is what we call it in the business. We can help you put together what looks like a reasonable order. We can help you package it up in a way that the courts will be acceptable to your argument. We can help you anticipate the kinds of questions that the counselor and the judge is going to be asking you, and we can help you present your case in a way that the judge and the court is going to accept it. That's why we're here, is to be a translator between your wishes and what the court is wanting to hear as far as arguments.
Thank you, Gina. And I do want to take this opportunity to thank our listeners, to thank our legal panel for taking the time out of their day to share this knowledge with us. I do want to remind everyone that these podcasts will be posted on our social media websites, YouTube channel, Facebook page, and our website. So if you have any questions, please feel free to refer to these podcasts. If not, you can easily reach us in one of three ways. You can reach us online at our website, which is www.temeculadivorce.com. You can call our office at 951-587-0505, or you can email us at info@temeculadivorce.com. Again, thank you guys all for taking the time, and I do wish that everyone have a wonderful day, and God bless.
God bless.
Bye.